Without recourse, the two words that cancel future liability. What if two words could eliminate your financial liability permanently? Discover the hidden legal power behind without recourse and how banks have used it for decades to shield themselves while keeping you in the dark. The phrase without recourse, though rarely understood by the layperson, holds tremendous legal power in the world of negotiable instruments and commercial banking. It is a term of art defined under UCC Section 3-414b and Section 3-419, signaling that the endorser of a negotiable instrument disclaims all future liability on the instrument's performance or payment. In practical terms, when a borrower signs a promissory note or check and endorses it without recourse, they sever all legal ties to that instrument once it is negotiated or delivered. The receiving party, usually a bank or lender, can still process the instrument, monetize it, or pledge it as collateral, but cannot return to the original endorser for additional payment, default claims, or contractual enforcement. This transforms the signed document from a debt obligation into a one-time conveyance of value, legally isolating the signer from future claims or liabilities. Once accepted, whether physically or constructively, such as through certified mail or automated processing, the instrument becomes final and non-reversible in its binding nature, by operation of both contract and commercial law. Despite this, most borrowers never use the term. Banks and lenders almost never disclose its significance. The omission of without recourse creates a legal vacuum in which the borrower unknowingly issues a blank check of perpetual liability. This is the central mechanism by which banks convert individuals into debtors for obligations that were already discharged at the moment of the initial signature. Notably, banks themselves almost always stamp the instruments they forward to the Federal Reserve without recourse. This tells the Fed, "We are not liable if this note fails," while simultaneously never informing the public that the same protection could be applied by the original signer. Footnote: this section reveals that endorsing financial instruments without recourse eliminates future liability and is commonly used by banks, yet almost never by the public.